Please be seated. The sitting is open. The court meets this afternoon to hear the remainder of the oral observations of the intervening states. For reasons duly made known to me, the Vice President is unable to sit with us this afternoon. I give the floor now to Dr. Gabija Grigati-Daugirda for Lithuania. You have the floor, Madam.
Good afternoon. Madam President, members of the court, it is an honor to appear before you as agent of the Republic of Lithuania in this important case. Previously, Lithuania took part in 2 cases and 1 advisory proceeding before the Permanent Court of International Justice. Soon after, it was illegally annexed by the Soviet Union for nearly half a century. Of injustice, and since resuming independence, Lithuania has always relied on international law to sustain its existence and freedom, and it consistently objected to the alternative international law narrative created by the Soviet Union and later by the Russian Federation. Today, for the same reasons and in quite reminiscent circumstances, Lithuania stands for the respect of the territorial integrity of a fellow sovereign state and against the blatant disregard of international law by the respondent under false pretext based on the Genocide Convention that formed the gist of this case. Today's hearings is dedicated to the court's jurisdiction under Article 9 of the Convention, and I have 2 points to make about the construction of that provision. My first point concerns the type of disputes that fall within the ambit of Article 9. My second point concerns the court jurisdiction ratione materia, that is, the claims that the court may entertain pursuant to that provision. I turn to my first point regarding the types of disputes that fall within Article 9. Members of the court, it is an undisputed proposition that Article 9 must be read in the context of the other provisions of the Convention. In this regard, contrasting Articles 8 and 9, the court held last year that, I quote, Article 9 provides the conditions for recourse to the principal judicial organ of the United Nations in the context of a dispute between contracting parties, whereas Article 8 allows any contracting party to appeal to other competent organs of the United Nations, even in the absence of a dispute with another contracting party. End of quote. Moreover, as the text of Article 8 makes clear, it is solely concerns, I quote, the prevention and suppression of acts of genocide or any of other acts enumerated in Article 3. End of quote. In contrast, disputes falling under Article 9 are not limited to the prevention and suppression of acts of genocide, but may more broadly, I quote Article 9, relate to the interpretation, application, or fulfillment of the present Convention, including those relating to the responsibility of the state for genocide or for any of the other acts enumerated in Article 3. And as the court also previously made clear, disputes relating to the responsibility of contracting parties for genocide are comprised within a broader group of disputes relating to the interpretation, application, or fulfillment of the Convention. Wherefore, the functional and textual differences between Article 8 and 9, that is, the distinct areas of application, indicate that disputes stemming from allegations of acts of genocide may be submitted to the court for adjudication, even if the claims submitted to the court by the applicant do not concern the perpetration of acts of genocide by the respondent. In other words, the court's jurisdiction under Article 9 extends here to disputes resulting from the contestation by the applicant of allegations by the respondent that acts of genocide occurred or were about to occur on the territory of the applicant. Lithuania considers that when a state accuses another state of committing genocide and that another state rejects such accusations, a dispute exists under Article 9 of the Convention. This includes instances in which the accusation of genocide is made with a view to justifying acts allegedly preventing genocide, which may, at the same time, engage other rules of international law. This construction of Article 9 is confirmed by two of its textual elements on which other intervening states rightly insist. First, under Article 9, a dispute can arise about the fulfillment of the Convention. This means that when one state protests against another state's allegations that genocide is occurring or about to occur, such contestation gives rise to a dispute about the fulfillment of obligations under the Convention. And secondly, Article 9 explicitly states that the season of the court can be the initiative of any of the parties to the dispute. Accordingly, such a dispute can be submitted to the court by either of the disputing states. To sum up on this first point, a state party that considers itself falsely accused of genocide by another state party may rebut such an accusation and submit the ensuing dispute to the court pursuant to Article 9. Lithuania submits that this construction of Article 9 entirely conforms with the terms and is also consonant with the higher purposes of the Convention and the preservation of its integrity. Madam President, members of the Court, I now turn to my second point, which concerns your jurisdiction ratione materia under the Convention. A state that considers itself falsely accused of genocide may notably claim that such accusation is the result of the breach of Article 1 of the Convention and that the actions undertaken for the alleged purpose of preventing the perpetrated genocide are likewise wrongful under the Convention. As Lithuania has set out in its Declaration of Intervention, the question of whether a party has fulfilled its obligations under the Convention may be particularly salient in relation to the obligation of due diligence entailed by Article 1, that is to collect substantial evidence from independent sources that acts of genocidal nature are being perpetrated before undertaking any preventive action pursuant to the same provision. Such a claim falls within the jurisdiction ratione materia of the Court under Article 9 of the Convention. Whether Article 1 entails an obligation of due diligence to collect substantial evidence before engaging in the prevention of an alleged genocide is a question of interpretation of the Convention that falls unquestionably within the Court's jurisdiction. And we further submit that such a question of interpretation would fall to be determined during the merits of this case, because Article 1 is not a provision that defines the scope of a treaty. Lithuania further recalls that, as the Court already made clear, the means by which an international obligation is allegedly breached are irrelevant for jurisdictional purposes. The nature of the means by which the respondent wrongly fulfilled the obligation to prevent genocide under Article 1 are thus entirely irrelevant at this stage of the proceedings and do not concern your jurisdiction ratione materia. This being said, the Court jurisdiction under Article 9 undoubtedly extends to disputes over the measures taken purportedly to prevent genocide pursuant to Article 1. Finally, Lithuania recalls that when the Court has jurisdiction under Article 9, such jurisdiction also extends to applying the rules of general international law on treaty interpretation and on responsibility of states for internationally wrongful acts. Lithuania respectfully submits that the Court's jurisdiction extends for the same purpose to applying other rules of treaty law, in particular the one concerning the obligation to perform treaties in good faith, when they are pertinent, of course, to the dispute at hand. Wherefore, claims concerning the breach of such obligations necessarily fall within the court's jurisdiction. This is all the more the case in relation to Article 1 of the Convention, because under that provision, the contracting parties solemnly undertake to prevent and punish genocide. Thus, under the Convention itself, the contracting parties are bound to perform such obligation in good faith. Madam President, members of the Court, I thank you for your kind attention. I also take this opportunity to thank my legal counsels, Professors Pierre Darjean, Glyde Hernandez, Inga Martincute, and Christian Tams, for their assistance in preparing Lithuania's submissions. Finally, I also express our gratitude to the Registrar, his staff, and the Court's interpreters for their professional and courteous assistance. Thank you, Madam President.
I thank Ms. Gayate Daugirde, and I invite Mr. Christophe Soler to address the Court on behalf of Malta. You have the floor, sir.
Madam President, honourable members of the Court, good afternoon. I have the privilege to stand before you today to submit oral pleadings on behalf of the Republic of Malta. At the outset, and by way of a preliminary observation, I declare that Malta adopts the conjoint submissions articulated by Belgium, Canada, Denmark, Estonia, Finland, Ireland, Luxembourg, Romania and Sweden throughout this morning's session. Malta does so in terms of the letter of the Registrar dated 23rd June 2023 and in adherence with the order of this Court dated 5th June 2023 respectively, wherein intervening states are encouraged to present joint written and oral observations to the extent possible, insofar as the joint presentation of shared views can advance the good administration of justice. Today's oral observations are intended and shall serve to complement the observations, both written and oral, of such like-minded states. Malta's intervention relates exclusively to the compromissory clause of the Genocide Convention. This being a broad and fairly straightforward jurisdictional clause that does not make that jurisdiction subject to any further special conditions. Hence, I shall focus on the proposition which Malta has advanced in Part 4 of its written observations. Essentially, an examination of the character of a norm can serve to act as a tool of interpretation thereof. I will first address the term fulfillment in Article 9 of the Genocide Convention. By endorsing the conjoint position of the like-minded states, Malta has already acknowledged the importance of the insertion of the word fulfillment for the purposes of an interpretation of the compromissory clause of the Genocide Convention. As Judge Oda noted in the Bosnian genocide case, the inclusion of the word fulfillment, which within Article 9 of the Convention, is unique as compared with the compromissory clauses found in other multilateral treaties. Therefore, the added value of the word fulfillment should be fully explored. I now turn to the legal relevance of the jus cogens character enjoyed by the norm prohibiting genocide. Such norms give rise to obligations owed to the international community as a whole, obligations erga omnes. This means that all the state parties to the Genocide Convention thus have a common interest to ensure the prevention, suppression and punishment of genocide by committing themselves to fulfilling the obligations contained within the Convention. Malta accepts the fact that a dispute relating to a norm having such character cannot of itself provide a basis for the jurisdiction of the court to entertain such a dispute. However, when interpreting a compromissory clause establishing the court's jurisdiction, the nexus between the word fulfillment and the jus cogens character of the substantive obligations under Article 1 of the Genocide Convention should be taken into account. In particular, the interpretation of Article 9 of the Genocide Convention should reflect and embrace the peremptory character of the prohibition of genocide. I shall now address the nexus between the word fulfillment and the jus cogens character of the prohibition in more detail. Insofar as disputes about the fulfillment of the Genocide Convention raise questions of compliance with other rules, the interpretation of Article 9 should take into account the jus cogens character of such norm. The interpretation of the word fulfillment requires engagement with the concept of compliance. This, in turn, calls for a closer analysis of the rule, which is to be complied with, including its inherent nature, its particular characteristics, and the consequences it engenders. Hence, the emphasis on compliance in this regard generates the need to interpret Article 9 in the light of the character of the underlying provisions. This is true both cumulatively, when the entire convention is interpreted in a logical manner with reference to its object and purpose, and individually, when only a clause thereof, such as Article 9, is interpreted in a literal manner with a focus on its ordinary meaning. In other words, a judicial organ cannot disentangle the character of a norm from the construction of that same norm, because the norm was not conceived and does not subsist in abstracto. The peremptory character of the norm is significant when a judicial organ like this court is entrusted to analyze the treaty provisions which unequivocally outlaw genocide. Such an approach, or a method of interpretation, is consonant with the tenet of effet utile. Furthermore, the travaux préparatoires confirm that the word fulfillment referred to the compliance or non-compliance of a party with the provisions of the Convention. The word fulfillment, therefore, had a much wider meaning than the word application. They reveal, in particular, that the word application included the study of circumstances in which the Convention should or should not apply, while the word fulfillment referred to the compliance or non-compliance of a party with the provisions of the Convention. The elasticity of the word fulfillment is revealed not only when compared to the word application, but also when compared to the word interpretation. The latter term, interpretation, describes the process of establishing the true meaning of a treaty, whereas fulfillment describes the extent to which the true meaning, scope, and spirit of the treaty are executed, implemented, enforced, and complied with by its signatories. Madam President, members of the Court, in view of the multilingual dimension of this Court, I shall undertake my concluding observations in French. Il s'ensuit que le clause compromissoire.
It follows that the compromissory clause, or compromissory clauses that refer to jus cogens provisions, as does in particular Article 9 of the Genocide Convention, are not to be interpreted narrowly. To decline jurisdiction in the instant case might lead to jeopardizing the special status of jus cogens norms in general international law, as enshrined in Article 53 of the Vienna Convention on the Law of the Treaties. I thank you for your kind attention.
I thank Mr. Soler, and I now invite Mr. Christian Jervel to address the court on behalf of Norway. You have the floor, sir.
Madam President, honourable members of the court, it's an honour to appear before you on behalf of the Kingdom of Norway. Norway is using its right to intervene in this case brought by Ukraine against the Russian Federation based on the Genocide Convention. This is the first time that Norway intervenes in contentious proceedings before the court. We do not do so lightly. However, it quickly became clear to us that this case raises legal issues of utmost importance not only to the Genocide Convention, to which Norway is a party, but more fundamentally to the integrity of the international legal order. The court's ability to play its critical role in this legal order is at the forefront already at this preliminary objections stage. It will remain so for the potential merits stage of these proceedings. Norway's remarks are made in this context. Turning now to the construction of Article 9. Norway considers that Article 9 raises three questions for the court to consider. Firstly, the court must ask whether a dispute exists in the case before it. If the court finds that a dispute exists, the next question is whether the court has jurisdiction ratione materiale to adjudicate this dispute. For this to be the case, the dispute must relate to the interpretation, application, or fulfillment of the Genocide Convention. If this is also answered in the affirmative, the third question is whether the court has been seized by one of the parties to the dispute. As always, the answers to these questions must follow from an application of the means of treaty interpretation, as they follow from customary international law and as reflected in the Vienna Convention on the Law of Treaties, Articles 31 to 33. Further analysis of these three questions can be found in our written submissions. To the third question, whether the court has been seized by one of the parties to the dispute, Norway submits that if the court finds that a dispute exists over which it has jurisdiction, ratione materiale, it necessarily follows from this conclusion that all parties to that dispute are entitled to seize the court. This is evident from the words any of the parties to the dispute in Article 9. In the court's words, it does not matter which one of them advances a claim and which one opposes it. Furthermore, the choice of the word shall in Article 9, as in shall be submitted to the International Court of Justice, affirms the intention that all disputes pertaining to the Genocide Convention were to be brought to the court's attention. In sum, the wording of Article 9, read in good faith and in context, clearly speaks against establishing a high threshold for the court's jurisdiction. This is further substantiated by the Convention's object and purpose. Of the different avenues available under the Convention, recourse to the court under Article 9 is particularly important. Ad hoc Judge Kress, in his declaration related to jurisdiction in the Gambia versus Myanmar, states, and I quote, "While the entitlement of a state party to invoke the responsibility of another state party for an alleged violation of an obligation erga omnes partes under the Genocide Convention is not the only way to act in the relevant common interest. A state's entitlement to seek judicial protection before the court significantly complements the other avenues through which it may uphold that interest." End of quote. Norway considers that the common interest and erga omnes partes character underpinning the Genocide Convention speak against narrowly construing the entitlement to seek judicial protection before the court. Such an interpretation would risk precluding a victim state from seeking relief from the court when faced with abuses of the Convention. This would undermine the Convention's credibility and efficiency as a universal instrument for the prevention of genocide, as well as the role of the court as a critical avenue for redress against abuses of the law. Now, as a second point, I will turn to the advancing of the good administration of justice. The Russian Federation has argued that the interventions made by other state parties in this case are not genuine, and that their goal is to pursue a joint case with Ukraine. This was initially forwarded as grounds for dismissal of the interventions, an argument the court correctly has rejected. However, we also understand this as an attempt to convince the court that the number and character of the interventions could interfere with the good administration of justice, and that this should impact the court's approach and procedure. Madam President, honourable members of the court, it is a matter of fact that a legal dispute of the kind where a state seizes the court rarely appears in a vacuum. Such cases will always exist within a broader context of both factual and political circumstances. This should not impact the court's legal assessment and method, which must always be based on the generally recognized means of treaty interpretation. In Norway's view, the good administration of justice is achieved precisely through the court performing its role in accordance with the statute and based on the rules of court, irrespective of the circumstances surrounding a particular case. This is the way to ensure that cases are addressed based on the fundamental objectives of fairness, impartiality and timeliness. If the court were persuaded to deviate from these rules, or to interpret them narrowly based on such external circumstances, it would be detrimental to the principles which the court seeks to uphold. For example, it is true that Norway has condemned the Russian Federation's war of aggression against Ukraine in the strongest possible terms as a blatant violation of international law in other relevant fora. However, and as confirmed by the court's decision on admissibility of Norway's intervention, this is not relevant for Norway's right to opine on the construction of the Genocide Convention under Article 63 of the statute as a means for other states than the ones at bar to provide their views to the court. Respectfully, the two are not mutually exclusive. Madam President, distinguished members of the court, this concludes my observations on behalf of Norway. Thank you.
I thank Mr. Yervell, and I now give the floor to Mr. Andrew Williams for New Zealand. You have the floor, sir.
Madam President, members of the court, it is an honour to appear before you today and to present New Zealand's submissions in these critical proceedings. New Zealand has chosen to intervene in these proceedings because we consider that the issues in this case go to the very heart of the international rule of law and the protection of this court's role in the peaceful settlement of disputes. Madam President, I do not intend to repeat every point put forward in New Zealand's written observations, nor will I rehearse the arguments made by Ukraine and the other intervening states in their written and oral submissions. We broadly support the points they have made. In particular, New Zealand supports the United Kingdom's analysis of the criteria for the establishment of a legal dispute. We also endorse the points that Australia made this morning regarding the scope of the court's jurisdiction ratione materiae under Article 9. And we agree with the arguments put forward by the other intervening states, confirming that this court clearly has the power to declare that an applicant state has complied with its obligations under the Convention. On all three issues, the Russian Federation seeks to artificially restrict the jurisdiction of this court in a manner that is inconsistent both with the plain language of Article 9 and the court's previous decisions. In New Zealand's view, there is nothing in the arguments put forward by the Russian Federation that warrants a departure from the jurisprudence of this court. Madam President, I will focus the remainder of my submissions on one specific element of New Zealand's written observations regarding the interpretation of Article 9. That is, how a party's outright refusal to comply with provisional measures may be relevant to the court's determination of jurisdiction under the Convention. As Ukraine has already set out in its written observations, and as elaborated by Mr. Gimlet yesterday, there is no question that this court can find that a party has violated a provisional measures order, regardless of how it may ultimately rule on jurisdiction. Such a violation is both an insult to the judicial authority of the court and a breach of the statute itself. In New Zealand's submission, however, a party's refusal to comply with provisional measures also carries two further important legal consequences. First, it can provide evidence of the existence of a legal dispute between the parties. And second, it is a substantive breach of Article 9 itself. Madam President, as this court recognised when applying Article 9 in the Myanmar genocide case, in order for a dispute to exist, there must be a clear conflict of legal views. The claim of one party must be positively opposed by the other. Further, and as the court stated in the same case, the conduct of the parties after an application is filed can provide evidence of the existence of a dispute. In determining whether a dispute exists, the court can look at what a party did and did not do after the application was filed. A party's refusal to comply with the provisional measures is a clear example of such conduct, where, in the defiance of the court's direction to stop, a party persists with actions that form the basis of the claim against it, and then justifies those actions on the very same basis as gave rise to the claim. The court may look to that as evidence. Evidence not just that the party denies the jurisdiction of this court, but evidence also of the existence of a legal dispute. Indeed, it is hard to imagine any stronger indication that a party positively opposes the legal and factual claims that have been made against it, or conduct that more clearly demonstrates that there is a conflict of views between the parties on the legal issues and their consequences. Such non-compliance acts as a complete rejection of the applicant's claims. It is conduct that speaks as loud as any words. But the consequences of a party's refusal to comply with provisional measures are more than evidential. In New Zealand's submission, such a refusal constitutes a substantive breach of Article 9 itself, thus creating a basis for the jurisdiction of the court. Madam President, Article 9 forms an integral part of the Convention. It serves the same high ideals as the rest of the Convention, which form the foundation and measures of all its provisions. Proper fulfilment of Article 9 is essential to the fulfilment of the objects and purposes of the Convention itself. Like all treaty obligations, Article 9 must be performed in good faith. The centrality of that principle, codified in Articles 26 and 31 of the Vienna Convention on the Law of Treaties, is beyond doubt. It is likewise established that the principle of good faith carries with it a duty to cooperate in the settlement of a dispute. That duty to cooperate, expressly confirmed by the Arbitral Tribunal in the South China Sea arbitration, mirrors the duty to cooperate in the context of negotiation, which was affirmed by this court in the North Sea continental shelf cases and has been consistently reaffirmed in the 50 years since. Article 9 is thus more than a merely procedural obligation. It also has a substantive character. Through Article 9, the contracting parties have agreed to a procedure for the settlement of their disputes. That is, the submission to this court. At the same time, they have assumed a substantive duty to cooperate and comply with all aspects of that procedure reasonably and in good faith. That duty applies equally to all states, whether large or small. A party to a dispute may breach its obligations under Article 9 in a number of ways. It may, for example, ignore the court's proceedings entirely, or it may reject the court's authority and refuse to comply with the provisional measures it has indicated. Such actions constitute a substantive breach of Article 9 itself. By failing to comply with the court's procedure, the party has breached the duty implicit within Article 9 itself. And that breach may in turn give rise to a dispute as to the application or fulfilment of the Convention, itself providing a basis for the jurisdiction of this court. Madam President, the impacts of a refusal to comply with the binding orders of this court extend well beyond the parties to an individual dispute. As the court has consistently found, most recently in the Myanmar genocide case, the obligations contained in the Convention are obligations erga omnes. It follows that all states parties to the Convention have an interest in securing compliance with those obligations, including the obligations in Article 9. A party's refusal to comply with provisional measures is a breach of Article 9, one with significant and far-reaching consequences. It undermines the high ideals of the Convention. It challenges the authority of this court. It aggravates the underlying dispute, and it threatens the maintenance of international peace and security. As this case demonstrates, those consequences are not merely theoretical. They are real, with political, economic, and humanitarian impacts that have been felt across the globe. Thank you, Madam President, distinguished members of the Court. That concludes the submissions of New Zealand.
I thank Mr. Williams, and I now invite Her Excellency Ms. Margareta Kasangana to address the Court on behalf of Poland. You have the floor, Excellency.
Madam President, distinguished members of the Court, it's an honor to appear before you on behalf of the Republic of Poland. Poland intervenes in these proceedings in its capacity as a party to the Convention on the Prevention and Punishment of the Crime of Genocide. My remarks will present views on the construction of Article 9 and other provisions of the Convention relevant to a determination of the Court's jurisdiction. These views can be divided into 4 main points. First, Article 9 is broadly formulated compromissory clause that does not contain any specific restrictions. Already in the Bosnian genocide case, the Court noted that Article 9 contains one unusual feature, distinguishing it from a standard dispute settlement provision, namely that the court's jurisdiction includes those disputes relating to the responsibility of a state for genocide. Article 9's ordinary meaning makes it clear there is no need to establish genocidal acts as a basis to affirm the court's jurisdiction. Article 9 does not entail any limitations for this type of judgments. Thus, where there is a dispute concerning whether a state has engaged in conduct contrary to the Convention, the state accused of such conduct has the same right to submit the dispute to the court as the state making the accusation. In particular, the context of the phrase "relating to" in Article 9 confirms that the court's jurisdiction extends beyond disputes between states over responsibility for alleged genocidal acts and also covers disputes between states over the absence of genocide and the performance of treaty obligation by one or more state parties. As a result, the court has jurisdiction over the question of whether genocidal acts have been or are being committed. Second, the Convention's object and purpose give further support to a broad interpretation of Article 9. As the Court noted in reservations to the Convention on Genocide advisory opinion, and I quote, "The Convention was manifestly adopted for a purely humanitarian and civilizing purpose, and its object on the one hand is to safeguard the very existence of certain human groups, and on the other to confirm and endorse the most elementary principles of morality." End of quote. The importance of the issue regulated by the Convention makes such an interpretation of particular value, as it can contribute to understanding the term genocide under the Convention and influence its appropriate further application. The exclusion of such types of disputes would run counter the Convention's provisions, as well as the humanitarian and civilizing purposes for which it was adopted. Third, Article 9 of the Genocide Convention applies to disputes about false and abusive allegations of genocide as they raise the question of compliance with Article 1 of the Convention. According to this provision, all state parties are obliged to prevent and punish genocide. As the Court already emphasized, the contracting parties must implement this obligation in good faith, taking into account other parts of the Convention, in particular Articles 8 and 9, as well as its preamble. A false and abusive allegations by the state against another runs counter the obligation to apply Article 1 in good faith, and thus distorts the terms of the Convention. Accordingly, Article 9 also covers such a dispute. Fourth, Article 9 concerns disputes about otherwise unlawful actions as a means for the prevention and punishment of genocide. Thus, as the Judge Robinson stated in his separate opinion, and I quote, "Article 1 of the Convention imposes an obligation on Russia not only to act to prevent genocide, but to act within the limits permitted by international law to prevent genocide." End of quote. The court jurisdiction under Article 9 of the Convention extends to disputes concerning unilateral action for the stated purpose of preventing and punishing alleged genocide, as it encompasses issues of interpretation concerning several provisions of the Convention. In conclusion, Madam President and distinguished members of the Court, Poland submits that the ordinary meaning of Article 9 of the Convention and its context, along with the Convention's entire object and purpose, show that a dispute regarding an act carried out by one state against another state based on claims of genocide falls under the notion of a dispute between contracting parties relating to the interpretation, application, or fulfillment of the present Convention. Thus, this provision concerns a situation in which one state raises the commission of genocide by another state, and the latter opposes such an assertion. As a result, if the representative on one state makes a general allegation that another state has committed genocide and tries to infer from this allegation certain rights, such a conduct is converted by the subject matter of the Convention. Certainly, such a behavior cannot be considered insignificant from the perspective of the Convention jurisdictional and substantive provisions. Finally, from a systemic perspective, it is posited that the Court, as the principal judicial organ of the United Nations, whose primary function is the preservation of international peace and security, has a positive obligation to contribute to that aim by providing a judicial framework for the resolution of legal acts, especially those which not only threaten international peace and security, but have escalated to a full-scale military invasion involving enormous human suffering and continuous loss of life. Madam President and distinguished members of the Court, I thank you for your attention.
I thank Her Excellency Ms. Kasangana, and I shall now give the floor to Ms. Patricia Galvão Teles for Portugal. You have the floor.
Madam President, honourable members of the Court, it is a great honour to appear today before you to convey the Portuguese Republic's observation on the construction of Article 9 of the Genocide Convention and other provisions relevant to the determination of the jurisdiction of the Court in the present proceedings. The Portuguese Republic has requested to intervene on the basis of Article 63 of the Statute of the Court, since, as a state party to the 1948 Genocide Convention, a cornerstone instrument of the current international legal order and for the protection of human dignity, it felt compelled to do so. Not by choice, but precisely because the construction of such a fundamental convention, to which Portugal is a party, is in question in the present proceedings. Madam President, members of the Court, in these oral observations today, we wish to convey to the Court our main points on the construction of the Genocide Convention concerning the Court's jurisdiction. Taking into consideration the specific claims before the Court, the Portuguese Republic wishes to submit 4 observations on the construction of the Genocide Convention, in particular of its Article 9, concerning the Court's jurisdiction as follows. 1. The claim concerns an existing dispute. 2. The dispute relates to the interpretation, application, or fulfillment of the Convention. 3. The dispute relates to substantive obligations under the Convention. And 4. The claim was duly submitted by one of the parties to the dispute. Allow me briefly to develop these 4 observations. First, the Portuguese Republic observes that the claim submitted by Ukraine concerns an existing dispute. The notion of dispute is already well established in the case law of the Court, which considers the meaning given to the word dispute as a disagreement on a point or law of fact, conflicting of legal views or of interest between the parties. As already determined by this Court on its order of March 16, 2022, and I quote, "The statements made by the state organs and senior officials of the parties indicate a divergence of views as to whether certain acts allegedly committed by Ukraine in the Luhansk and Donetsk regions amount to genocide in violation of its obligations under the Genocide Convention, as well as whether the use of force by the Russian Federation for the stated purposes of preventing and punishing alleged genocide is a measure that can be taken in fulfillment of the obligation to prevent and punish genocide contained in Article 1 of the Convention." Unquote. Moreover, it follows from the established case law of the Court that certain facts or omissions may give rise to a dispute that fall within the scope of more than one treaty. Hence, a parallel dispute arising out of the same facts does not create an obstacle to the jurisdiction of the Court under Article 9 of the Genocide Convention, provided that its conditions are fulfilled. Second, the Portuguese Republic further observes that the dispute relates to the interpretation, application, or fulfillment of the Convention. The Portuguese Republic is of the view that Article 9 constitutes a broad jurisdictional clause, allowing the court to educate upon a vast array of disputes concerning the interpretation, application, or fulfillment by a state party of its obligations under the Convention. As the court has stated before, the inclusion of the term fulfillment is unique as compared to with other compromissory clauses found in other multilateral treaties, which provide for submission of the court of such disputes between contracting parties as relate just to the interpretation or application of these treaties in question. It appears that by inserting all the three alternative terms, the drafters of the Convention had thought to give a coverage as exhaustive as possible to the compromissory clause and to close down all possible loopholes. In particular, the term fulfillment supports a broad interpretation of Article 9. In addition, the use of the expression of the Convention confirms the broad scope of the compromissory clause. It makes clear that Article 9 relates to the entirety of the Convention, including the wide range of provisions thereof. Third, the Portuguese Republic is of the view that the dispute in question relates to substantive obligations under or connected with the Convention. In fact, the jurisdiction ratione materia of the Court includes the competence to address allegations of genocide that contravene the limits imposed by international law, as they raise the question of compliance with Article 1 of the Convention, which in turn provides the context for the construction of Article 9. In accordance with Article 1 of the Convention, all state parties are obliged to prevent and punish genocide by employing all means reasonably available to prevent genocide as far as possible. However, in fulfilling their duty to prevent genocide, state parties must act within the limits permitted by international law, including, among others, the limits imposed by the definition of genocide, the principle of good faith, the prohibition of abuse of law, the obligation to settle disputes peacefully, and the principle of sovereignty. A state may not claim to enforce international law by violating international law. Therefore, if a state acts beyond the limits permitted in international law in the case at hand, the acts of that state would constitute a breach of the Convention. For genocide to occur, there is a requirement to establish, based on compelling evidence, both genocidal action and a specific genocidal intent next to the mental element present in the acts listed in Article 2. Where a state has not carried out a good faith assessment of genocide or serious risk of genocide, it cannot invoke the undertaking to prevent genocide in Article 1 of the Convention as justification for its conduct. This includes conduct that involves the threat or use of force that would be contrary to international law. The Convention's object and purpose and the high values and principles it protects also prohibits any possibility of a state party to abuse its provisions and invoke them from any other purpose other than those foreseen in the Convention. Furthermore, it results from Article 8 of the Genocide Convention that the prevention and suppression of genocide is not a domestic matter, but concerns the international community as a whole. State parties may call upon the competent organs of the United Nations to take necessary action under the Charter for the prevention and suppression of acts of genocide. This includes the Security Council, the General Assembly, and as well the court itself. Also, it is Portugal's view that the court has jurisdiction ratione materia to declare the absence of genocide when a state makes false allegations that are not based on existing facts, thus constituting a violation of performance in good faith of the obligations under the Convention, resulting in an abuse of its provision. The Convention's credibility would be undermined if its authority could be abused by any state party without possibility of review by the court. Fourth, any party to the dispute may seize the court under Article 9, including in particular the party which is the victim of an abusive allegation of genocide or any unlawful action as a means for prevention and punishment of genocide. To put it briefly, this is, in our view, the case in the current proceedings. Madam President, honourable members of the Court, in conclusion, the Portuguese Republic is of the view that the observations just presented should inform the construction of Article 9 in what concerns determination of the jurisdiction of the Court in the present proceedings under the said article and other relevant provisions of the Genocide Convention. I thank you for your attention.
I thank Ms. Galval-Teles, and I now give the floor to Ms. Victoria Prentice for the United Kingdom. You have the floor, Madam.
Madam President, members of the Court, I have the honour to appear before you on behalf of the United Kingdom as Attorney General. My submissions will focus on the Court's subject matter jurisdiction. The Court is engaged in the task of determining whether, on a proper construction of Article 9, it has subject matter jurisdiction over this dispute. To perform that task, it is necessary to characterise the dispute objectively. That requires close attention to Article 1 of the Convention. In that article, the contracting parties undertake to prevent genocide. In this case, at least 3 issues of interpretation arise just from the words "undertake to prevent." The first is whether a state must exercise due diligence in good faith in determining whether genocide is taking place or that there is a serious risk that it might take place. The second issue arises where a state takes measures purporting to fulfil its obligations to prevent genocide. The issue is whether it must act in good faith in choosing measures of prevention and in implementing them. The third issue relates to the second but is more specific. It is whether, when fulfilling its obligation to prevent genocide, a state must avoid measures that would breach the international law prohibitions on aggression, war crimes, or crimes against humanity. Those are questions of construction. The related questions of application and fulfilment are whether those limitations on the performance of Article 1 have been complied with. Article 9 gives the Court jurisdiction over all of those questions of interpretation, application and fulfilment. Madam President, in this case, the Russian Federation asserts that Ukraine's case requires the Court to exercise jurisdiction in respect of rules extrinsic to the Genocide Convention. It contends that Ukraine is attempting to, and I quote, expand the Court's jurisdiction under Article 9 over matters that manifestly fall outside the subject matter of the Genocide Convention, end quote. The real debate, however, is about whether Ukraine is attempting to expand the scope of Article 1. That is exactly the kind of debate over which Article 9 gives the Court jurisdiction. In that context, let us look at the good faith requirements within Article 1. The Court has explained that the principle of good faith obliges the parties to apply a treaty in a reasonable way and in such a manner that its purpose can be realised. Indeed, the Court has recognised good faith as one of the basic principles governing the performance of legal obligations, whatever their source. In this case, the Court has already indicated that the contracting parties to the Genocide Convention must perform or fulfil Article 1 in good faith. The question of whether the undertaking to prevent genocide includes good faith requirements plainly comes within the court's jurisdiction. It is a question of the interpretation of Article 1. A dispute as to whether a contracting party has in fact performed that undertaking in good faith is a dispute relating to the application or fulfilment of Article 1. It therefore also falls within the court's jurisdiction. By certain conduct, a state may purport to fulfil the undertaking to prevent genocide, but not do so in good faith. By the same conduct, a state may simultaneously breach other rules of international law, in respect of which the court has no jurisdiction. That does not affect the court's jurisdiction over a dispute relating to fulfilment of the Genocide Convention. Madam President, I now turn to the rules of international law said by the Russian Federation to be extrinsic to the Genocide Convention. The Russian Federation argues that, I quote, "The Convention does not incorporate an indefinite scope of other rules of international law, including those in relation to the use of force, territorial integrity, self-determination, and the recognition of states, through an alleged implicit obligation to act within the limits of international law," end quote. On Monday, the Russian Federation argued that Ukraine was asking the court to incorporate all of international law into the Genocide Convention. In the Bosnian genocide case, the court observed that in performing obligations under Article 1, every state may only act within the limits permitted by international law. The Russian Federation argues that this statement is inapplicable because it was made in a case where the respondent state was accused of failing to take action to prevent genocide. That distinction is irrelevant. The court was explaining limits that would constrain a state in performing its Article 1 obligations. The court has already cited that part of Bosnian genocide in the present case when it observed that acts undertaken by the contracting parties to prevent and to punish genocide must be in conformity with the spirit and aims of the United Nations. In its preamble, the Genocide Convention makes clear that its object and purpose is to prevent a crime under international law, contrary to the spirit and aims of the United Nations and condemned by the civilized world. Along the same lines, the court has stated that the Convention was manifestly adopted for a purely humanitarian and civilizing purpose, with its object being, on the one hand, to safeguard the very existence of certain human groups, and on the other, to confirm and endorse the most elementary principles of morality. Article 1 must be interpreted to reflect this object and purpose. This means that measures taken pursuant to Article 1 to prevent genocide cannot involve aggression, war crimes, or crimes against humanity. Commission of these crimes is evidently not compatible with the Genocide Convention's humanitarian underpinnings. Such crimes may generate responsibility outside the Genocide Convention under different rules of international law. Their commission may also be inconsistent with the constraints in Article 1 of the Genocide Convention, including the requirement for good faith. A dispute about whether such conduct is inconsistent with those constraints would relate to the application and fulfilment of the Convention and therefore be within the court's jurisdiction. The scope of other rules of international law that constrain conduct permitted by Article 1 is not indefinite. In other cases on which the Russian Federation has relied, The Court has found that rules of international law extrinsic to the treaty in question were not relevant to its interpretation. This was because rules were unrelated or simply not germane to the treaty's object and purpose. This is not the case for the constraints within Article 1. These constraints are not extrinsic to the Convention, rather they are embedded within it, consistently with the object and purpose of the Convention. It is unthinkable that a state fulfilling its undertaking to prevent genocide in good faith could do so through aggression or other international crimes. Madam President, members of the Court, those are the submissions of the United Kingdom. I thank you for your attention.
I thank Ms. Prentice, and I now invite Mr. Marko Rakovic to address the Court on behalf of Slovenia. You have the floor, sir.
Madam President, distinguished members of the Court, it is an honor to appear before you and to do so as agent of the Republic of Slovenia. We have the highest respect for this Court and its important mission to ensure the respect for international law, of which it is the organ. Therefore, we are grateful for the opportunity to present Slovenia's observations on the construction of the Genocide Convention and to assist the Court in accomplishing its mission. Madam President, today, the Court had the opportunity to listen to the observations and presentations of my colleagues from other states intervening in the present case. The Republic of Slovenia will not try to summarize these observations, but, as you will have noticed, the positions of the intervening states concerning the proper construction of Article 9 of the Genocide Convention are fully aligned. Counsel for the Russian Federation suggested on Monday that the interventions were part of, I quote, a massive intervention campaign, end of quote, and an abuse of process. You have already rejected this unfounded allegation in your order of 5th June. Indeed, the large interest of other states in the construction of the Genocide Convention shows the importance and the value attached to the Convention itself, to its proper interpretation and application, and to its integrity, which are essential for the realization of its purely humanitarian and civilizing purpose. Moreover, the similarities in the positions expressed by intervening states attest to the soundness of their construction of Article 9 and other provisions of the Convention. Mindful of the Court's order of 5th June, which you recalled on Monday, the Republic of Slovenia will draw the Court's attention to 3 points concerning Article 9 of the Convention. Madam President, members of the Court, the jurisdiction and authority of the Court under Article 9, and this is my first point, is not limited to the assessment of whether a state is responsible for acts of genocide. The Russian Federation suggested repeatedly on Monday morning that the Court's jurisdiction is, I quote, limited to breaches of the Convention, end of quote, or that, I quote again, one would expect an applicant under the Genocide Convention to claim that a contracting party had failed to prevent genocide, end of quote. Of course, Article 9 specifically refers to disputes relating to the responsibility of a state for genocide. But this is only one kind of dispute specifically included by the terms of the provision. Article 9 does not restrict the Court's jurisdiction to disputes concerning the breach of the obligation not to commit genocide. The drafters of the Convention have carefully formulated Article 9 in order to grant Court with the most comprehensive jurisdiction in respect of the Convention. As has been recalled by Ukraine and the intervening states, and is readily apparent from the text of the provision, the contracting states entrusted the Court with jurisdiction on any dispute relating to the interpretation, application or fulfillment of the Convention, submitted at the request of any of the parties to the dispute. The text and scope of Article 9 include the situation considered, I quote, unusual by the Russian Federation, where a contracting state submits that it has been the object of false accusations of genocide and claims that it had not committed genocide. This brings me to my second point, Madam President. The text of Article 9 leaves no doubt. Any dispute can be submitted at the request of any of the parties to the dispute. The state claiming that the genocide was or is committed by another state, but also the state that is falsely accused of having committed genocide. There is no reason why, under Article 9, a state could not have recourse to the court in order to establish that no genocide has taken place. It is plainly a question relating to the interpretation, application, and fulfillment of the Convention. In any event, it is unreasonable to suggest that a state accused of having committed genocide and against which another state has taken measures relying on its obligation to prevent or to punish genocide must wait for the latter to institute proceedings before the court. Such a narrow interpretation of Article 9 is not only contradicted by the ordinary meaning of its terms, it would also deprive the court of its essential role within the system established under the Convention. The proper construction of Article 9 thus proves the arguments of the Russian Federation concerning what it called, I quote, a reverse compliance declaration, end of quote, wrong. A request that a state has not committed genocide does not only fall within the terms of Article 9, it is also entirely consistent with the mission and judicial function of the court. Being a court of law, its function includes, as recalled by the statute, deciding legal disputes concerning the interpretation of a treaty and those concerning the existence of any fact which, if established, would constitute a breach of an international obligation or not. Contrary to the allegations of the Russian Federation, a judgment on the issues submitted in the present proceedings is not a simple academic exercise. The court will state the law in connection with a concrete case. Its judgment will have practical consequence and remove uncertainty from the legal relations of the parties concerned, to use the word of the court's judgment in Northern Cameroons. Indeed, your judgment will clarify whether a state has committed genocide or not, and whether another state wrongfully relied on Article 1 of the Convention in order to implement measures punishing or preventing alleged genocide. Madam President, members of the Court, this brings me to my third and last point. The Republic of Slovenia considers, in line with the position expressed by other states today, that under a proper interpretation of Article 9, the Court has also jurisdiction on the question of the measures implemented and of the means deployed by a state in order to purportedly comply, indeed to fulfill its obligations under Article 1 of the Convention. This too is a question relating to the interpretation, the application, or the fulfillment of the Convention. The Convention provides guidance on the means of the implementation of its obligations. In particular, it establishes mechanisms for its proper implementation through international cooperation, to which the Republic of Slovenia attaches utmost importance. The fulfillment of the purported reliance on the obligation to prevent and to punish genocide must be also assessed in light of the general principle inherent in any treaty of good faith application as codified in Article 26 of the Vienna Convention. It must also be assessed, as you recalled, in light of the limits permitted by international law. These questions and the consequences that result from an incorrect, abusive application or fulfillment of the Convention will fall within the scope of Article 9. This holds true even if and independently of the different issue whether considerations that are claimed to lie outside the Convention may be involved. As recalled in the appeal relating to jurisdiction of the ICAO Council case, and I quote, "The fact that the defense on the merits is cast in particular form cannot affect the competence of the tribunal or other organ concerned. Otherwise, parties would be in a position themselves to control that competence, which would be inadmissible." End of quote. Madam President, members of the Court, The correct construction of Article 9 is not only an issue particular to the present proceedings, it has far-reaching consequences for the integrity of the Convention and for the essential role of the Court in the implementation and correct application of this landmark human rights instrument at the eve of its 75th anniversary. The Court has been entrusted with the power to deal with these questions, and it must exercise that power to its full extent. Madam President, this concludes Slovenia's observations and brings an end to this long day of pleadings. Since I am the last speaker today, allow me to thank, in the name of intervening states, the registry, its staff, and the interpreters for their assistance and smooth organization of today's hearings. I thank you for your kind attention.
I thank Mr. Rakovic. Your statement brings to an end this afternoon's session. The court will meet again on Monday, 25 September, at 10 a.m. to hear the second round of argument of the Russian Federation. The sitting is adjourned.